I'm really pleased to be here. Thank you very much to Lilia for reaching out to me and inviting me. I feel quite honored to be in good company here. I think it's a really interesting, great initiative that you have, and I just hope that based on my work I can speak to the issues that you or show, in a sense, how I've tried to grapple and come up with a method that would usefully enable me to study what I wanted to study about how working time regimes are specifically gendered, yet that their gendering is not, or how gendered they are is not really apparent. I will not actually be talking about the aspect of book that specifically looks at how working time regimes are, or how working time norms are gendered themselves. What I will be looking at is the process of policy making and how gendered working time norms get reproduced in the process of policy making without being challenged. So that will be the aspect that I'll be focusing on today, because I wanted to focus on the things that were more where I could really pull my methodological approach a little bit more explicitly. But before I get there, I wanted to start with a personal anecdote. This is an experience from my doctoral upgrade, which took place a few years ago at the University of Victoria in Canada, where I did my PhD. After I presented my thesis proposal, which elaborated how I would conduct a feminist study focused specifically on a piece of gender-neutral EU regulation to discover, among others, what were its gendered impacts, one member of my interdisciplinary committee, who was a political scientist, repeatedly insisted that I explain to her why I thought it appropriate to analyze in this very way an instrument that had nothing to do with gender or gender equality objectives. And this was not a friendly critique, because it was fairly evident to me from the way in which she posed her questions and insisted on a more thorough explanation that she thought that I was really forcing the gender issue where it didn't belong. But although I was a bit taken aback by the questions she asked, her critique was actually quite illuminating and useful, because it made me really reflect more systematically on the question of how it is that we make visible that which is not, and how is it that we could study this process of erasure in our work. Of course, revealing gendered assumptions that underlie facially neutral norms is a key way in which feminist scholars, many of whom are sitting in this room, have long critically engaged with the law. And some have referred to this process as a process of gendering law, which is a process of systematically chipping away at law's apparently neutral facade to reveal its biases and assumptions, its constitutive role in reproducing social relations and in engendering inequality, and then working to change those assumptions and reform legal norms in a way that is more likely to facilitate substantive equality. So in asking these questions of myself, I was of course building on, but also seeking to contribute this longer-term feminist project in law. And in my presentation today, I will address the question of how is it that we can understand and study the process by which gender gets written out of law, by drawing on my forthcoming book entitled Gendering European Working Time Regimes. The book is, I'm told, hitting the press in about 2 weeks, so it's not published yet, but it's coming very soon. In a nutshell, the book critically examines the development of the EU approach to regulation of standard work hours and assesses whether this approach is consistent with and supports a range of other progressive goals that the EU policy appears to be also aspiring to. Promotion of equality or reconciliation of work and family, for instance, are some such aspirations and objectives. One of my book's contributions is to show how gendered assumptions underlying traditional labor law norms associated with standard employment, specifically those that relate to regulation of normal work hours, have been ultimately reproduced in the EU's approach, even if in a somewhat modified way. And this happened despite these seemingly egalitarian aspirations in EU social policy. I already forgot to shift my slides. So the book shows also the implications and consequences of this reproduction for both the subsequent efforts to reform the EU's regulatory approach in this area, and for labor law reforms, in particular EU member states. And the case that I looked at closely was Poland. But this being a reflection on methodology, I'll of course try to tell you about how it is that I went about studying this process by which the EU working time regime became what it was. And as I will suggest, a contextual study of legal instruments and legal reforms, which is attentive to the discursive universe within which these instruments and reforms have developed, and which pays particular attention to the relative roles of various actors who are engaged in the process of legal reform or legislation, can be very revealing as to why certain rationales, priorities, and objectives get reflected in law while others get written out of law. So my presentation will be structured in the following way. I will first tell you more about my choice of case studies. I'll then explain my approach and the key concepts that I drew on and the methods that I used in studying how different ideas and priorities become dominant while others become marginalized. I then will demonstrate how I applied this method and what I found. And I'll end by reflecting on the usefulness of this method and hopefully also addressing some of the broader themes of today's workshop, seminar. So, as I already shared, the book's focus is on the European Working Time Regulation, and the case studies that it uses are the EU Working Time Directive and the working time rules prescribed by the Polish Labor Code, and it also explores the interaction between those two sets of norms. Both sets of regulations are paradigmatic working time standards. They establish the maximum ceilings for daily, weekly, and weekly hours of work. They prescribe daily, weekly, annual breaks. And importantly, they also provide for a range of derogations and exceptions from these protective provisions so as to enable adaptation of working hours and patterns to the needs of business and to a much lesser extent to the needs of employees as well. In my talk today, I will primarily focus on the Working Time Directive because time doesn't permit me to speak to both cases. And I invite you to read the book if you are keen to explore the Polish case. But where it is relevant, I will bring in Poland as well. And I chose the directive specifically because of its gender-neutral framing and the fact that it was the first instrument on working time adopted at the EU level, and it was addressing normal working hours. And in that sense, it set a foundation for the broader EU working time regime that later developed. As most of you will know, the directive was adopted in '93 as a health and safety instrument, which itself was not controversial, given that working time has historically been regulated with preservation of health and safety and leisure in mind, or I should say it shouldn't have been controversial for that reason. But as it is well known, the directive was steeped in controversy from the beginning, in fact from before even it was enacted. And two aspects of it that were especially contested were first the fact that the UK had long opposed it, yet the Single European Act treaty changes enabled the European Commission, to propose the directive under a new community competence in the area of health and safety and subject to a qualified majority vote, which enabled them to sidestep the potential UK veto in Council negotiations and voting. The second controversy related to the many derogations and exceptions which the directive had, partially because of UK's role in the process of negotiation and insisting on having those exceptions and derogations. And those exceptions and derogations tended to significantly undermine the health and safety purpose for which the directive was being adopted in the first place. So those were some of the controversial issues that dominated the discussion. But what attracted less attention in this debate around the directive was, what ultimately was of more interest for me and became the focus of my study, was how the directive came to be framed in a gender-neutral manner, and more crucially, why it continued to be framed in this way after its 2003 recasting and in the process of its failed renegotiations. And all despite the fact that broader EU policy discourse had by then been full of references to equal opportunities, work-family reconciliation, and other related goals and objectives. And importantly, other instruments regulating aspects of working time and temporal accommodation, which were adopted a few years later after the directive, so the part-time work directive and the parental leave directive, were very explicitly justified with such objectives in mind. And two comparative institutional policy scholars, Deborah Figart and Alan Mutari, noted, they commented on this what they saw as a bifurcation of this EU working time regime. And so how did this bifurcation come about, and why was the directive framed so differently? So the approach to try to answer these questions, I decided that I required an approach that was not only feminist in its attention to gender, and what I'm not discussing is one of the components of my kind of conceptual framework was to show how working time norms developed historically to assume a certain relationship between the process of production and social reproduction. So it was apart from knowing that a feminist perspective that's attentive to gender is something that I need to unpack this this kind of silencing around gender, or this gender neutrality of the directive. I also knew that I needed an approach that was socio-legal and interdisciplinary, so I could pull on a range of different concepts that weren't necessarily available to me within law. Because what I wanted to study were not only the instruments themselves, but also the surrounding policy debates, and indeed the broader political economic background against which these policies were being shaped and developed over time. Of course, this kind of contextualization is something that lawyers often do in any case when we seek to better understand and interpret legislative intent, for instance. But I wanted to develop a more robust and systematic way of studying not only what the intended purpose of the legislation is, but also how and why certain rationales come to dominate while others become irrelevant or marginal. I also wanted an approach that would probe how law and politics interact or intersect, and which would enable me to see law itself as a political process, yet one that retains certain unique features. So I found that a particularly useful way of examining the policy or lawmaking processes and the relational and constitutive role of politics and law and their transformative potential was to conceptualize them as taking place within and reflective of a particular universe of political discourse, or a discursive universe. And this is a universe which, in a context of EU space, is also characteristically multi-level and informed by various similar universes operating at different scales. So this attention to multi-level regulation was another element of my conceptual framework that sort of I applied also to this concept of universe of political discourse. And I'll take a few minutes to explain this concept in more detail, because it served as one of the key components of the way that I framed my study, but it also really guided my methodological choices. So the universe of political discourse is a concept that I draw from the work of a Canadian political scientist, Jane Jensen, but also Pierre Bourdieu, who also talked about a discursive universe in his work. Jensen elaborated this concept in her comparative work on social policy developments to highlight the ways in which feminist concerns have been taken up in different national contexts to a greater or lesser extent, and with different consequences for gender relations, depending on the locally specific conditions that made for environments that were more receptive or less receptive to such concerns, but also because of presence of actors and alliances that were willing to push for inclusion of those concerns in the mainstream policy. According to Jensen, all norms and institutional arrangements emerged out of complex struggles over meaning, representation, power, legitimacy, in which social actors engage. The context for these struggles is the universe of political discourse, or as Bourdieu puts it, it's the universe of thinkable political possibilities delineated by political field. And as you'll see, I added legal because I think I was trying to extended to thinking about a legal legislative process. Although both the social relations and thinkable possibilities are always in a state of flux, they can nonetheless take on stabilized forms during certain historical periods and be reproduced over time. And Jensen explains that this kind of stabilization occurs when compromise is reached within this discursive universe, which makes for the emergent societal paradigm or a system of interconnected meanings so widely shared by different actors that it becomes hegemonic. And since all struggles over meaning and representation are ultimately fraught inequalities in access to power and influence over this discursive universe, these hegemonic paradigms will inevitably subordinate or exclude some identities and alternative competing meanings that too are represented in this universe of political discourse. And this subordination occurs because participation in this political field or the political process requires knowledge of this field. And then this knowledge, along with one's social position and access to resources, affects one's ability or a group's ability to participate and have their interests represented. And absent this knowledge, some meanings inevitably get filtered out of this discursive universe, and the universe or the universe of what is even thinkable. And Jensen posits that opportunities do arise for those temporarily subordinated identities to extend their representational reach and strength, and those opportunities surface particularly during periods of crisis, which occurs when the dominant or hegemonic paradigm's ability to absorb its internal contradictions becomes compromised. And the moments of crisis is when a shift within a hegemonic paradigm is possible, and it is then that this paradigm can be enriched with contributions from actors who gained a new representational strength. So now I spent some time to tell you about this concept because I wanted to make sense for why I thought it was useful to studying the process of erasure. I found it, although the concept is developed in reference to dynamics of political representation, I did find it very useful to conceptualizing and understanding the historical process through which certain rationales, such as those that justify policy choices and legislative activities, become dominant or hegemonic in Jensen's language, and why others become subordinated. And I found this concept particularly compelling because without ignoring the raw and materiality of institutional structures, norms, and legal rules, it also attends to human agency by showing that those very structures are themselves products of negotiations and struggles, and as such can be challenged and transformed given the right historical circumstances and a presence of particular strategic alliances. And so from this perspective, the key discourses on the role of law, organization of production activities, the regulation of working time that dominated the EU or national debates, can be also seen as certain negotiated settlements that reflect historically and contextually specific power dynamics which nonetheless can be destabilized over time. And in the same way, the extent to which the discursive universe has recognized, represented, and has been open to claims for gender equality, a particular division of responsibilities for paid and unpaid work, or the need to better support women and men in balancing their participation in employment and unpaid family obligations, also reflects settlements and underlying power dynamics, yet it also is subject to change. So who are the actors who are most pertinent to shaping this discursive universe on working time specifically? At the EU level, I try to represent this discursive universe as one that's composed of a range of different actors who feed into it in a sense. They enrich this universe. So in order to attend to this multi-level kind of character of this discursive universe, I also include transnational policy setting bodies like the OECD, ILO, or the World Bank, IMF, who also have had ideas about working time and have very actively tried to influence policy around working time, especially working time flexibility. Of course, at the European level, there are various EU institutional actors: the European Commission, the European Council, the Council of the EU, the European Court of Justice or Court of Justice of the European Union, the European Parliament, various bodies within those umbrella or those larger actors. But also, it's not just the official kind of actors. Social partners, who are the representatives of trade unions and labor on the one hand, and employer organizations on the other, are also actors that feed into and kind of shape and create this universe of political discourse. European member states, of course, acting through the institutions, and then also civil society. So at various times in the process of EU's expansion and development, it became possible for a broader range of civil society actors and organizations and lobbies to be able to feed into the kind of the policy debates at the European level. So I also have included here the Polish universe of political discourse, because there is obviously, I mean, even before Poland became a member state and was able to actively kind of shape this universe, it was in a sense within the shadow of this European discursive universe, and but also the process of enlargement was very much something that was in the back of mind, or not even in the back of mind, but it was very present in the discussions around also working time regulation at the European level. So I try to show that that this is a complex kind of multi-level or multi-layered entity. And similarly, then if we flip it, I will not be talking about the Polish case so much at the moment, but I just wanted to include the slide to suggest that it's in the sense the same in the Polish context. There are various actors who feed into this and create this universe of political discourse. Again, political parties, civil society, various lobbies and interest groups, the social partners who act at the European at the national level, but also EU and those various transnational policy setting bodies that I mentioned in the context of Europe. Given the extent to which particular actors are able to exert influence over the discursive universe and influence concrete policies and institutional forms at either the domestic or supranational level, of course, varies over a course of time. And as Jensen suggests, it is often in periods of crisis or upheaval that those are the moments that provide opportunities for broadening the discursive universe. So in my study, I try to also capture major shifts in institutional architecture and political economy as significant historic moments during which shared hegemonic meanings are disrupted and potentially renegotiated, with concrete implications for legal rules and social, including gender relations. So in my study, I paid particular attention to the broader political economic trends, periods of crisis, economic downturn, or opposite, as well as key events that took place at the EU level, especially the process of EU's geographical enlargement and the accompanying treaty change. Changes in EU's institutional structures, voting rules, and legislative procedures were significant because they led to two related shifts, both of which have again shaped the EU's discursive universe. The first shift was the successive legal and institutional changes precipitated the progressive expansion of the community's competences over various areas of social policy, including working time, the areas that were previously reserved for competence of member states. And through this, this expansion enabled certain actors not previously able to feed into this discursive universe to now have a voice. Secondly, the roles and relative influence of particular institutions within Europe and vis-a-vis each other. So particular European institutions and then European institution vis-a-vis each other, their influence also changed over the course of treaty change, because again, the treaty stipulated that consultations should be broader beyond, for instance, social actors, or that the European Parliament now held a stronger position as a legislator vis-a-vis the European Council. And so this also really changed the field, or it gave voices to some actors in the process of EU policy making that they didn't have previously, or strengthened voices of others. Okay, so now how did I apply this conceptualization? I went ahead too quickly, but how did I apply this conceptualization in practice in my study of the EU's discursive universe on issue of working time regulation? And how did I try to capture the way in which this universe shaped the regulatory design of the Working Time Directive? So in order to distill what were the key ways in which working time was being discussed and framed, and which rationales were being identified as pertinent, I conducted an extensive documentary review. This included both review of existing secondary literature on the key trends and developments in working time regulation, both at the EU level and more broadly, as well as extensive review of all relevant legal and policy texts. So I looked at EU legal instruments, including the treaties, the pertinent directives, various preparatory documents, recommendations and drafts, and the framework agreements that were concluded between social partners. So both hard and soft forms of regulation. I looked at communications from the Commission, the Council, the European Parliament, which were pertinent to the Working Time Directive, and its ongoing revision, which I was also tracing. All those were also analyzed, as were the position papers of social partners organizations on the official kind of proposals that were made for either the directive or its change later. I repeated the same process for the purpose of my Polish case study. I forgot to add, what I also looked at were various white and green policy papers which the European Commission issued, a range of strategic documents including roadmaps to equality, and reports that were prepared for various groups of experts, which the European Commission consulted with. And this documentary review enabled me to identify the key discourses on working time, or what objectives its regulation should or could facilitate, that were permeating the EU's broader policy discourse. And the main ones were health and safety and protection of leisure, which was a historic reason for regulating working time, but also organization needs and flexibility to adapt work patterns to hours of work in order to suit the production process. And that was also always a historically relevant rationale for regulating working time. However, redistribution of work to tackle unemployment, reconciliation of work and family, and promotion of equal opportunities for the purpose of women's employment, as well as through redistribution of paid and unpaid work time between women and men, were also rationales that featured in the working time discursive universe at some point or another, not only in the context of instruments like part-time work or parental leave, but also in the context of the policy instruments that were speaking to normal working time, regular work hours. Mapping these various discourses present within this broader policy onto the developing EU instruments, beginning with the preparatory works, consultation papers, draft and opinions, and eventually the final directive, made it more visible what was being taken up and what was being pushed to the sidelines within the law. At the same time, mapping both against the broader political, economic and institutional changes, including what other priorities and objectives were dominant at the time and who got to have a say according to the existing constellations of power, of actors wielding power and influence, made it also clear why certain rationales for working time regulation were more likely to dominate and why others were being marginalized. In addition to the textual analysis, I also conducted, I will come back to this slide, I jumped ahead a little bit. In addition to my text analysis, I also conducted a number of interviews with key informants representing the main actors involved in policy and regulation of working time. And not all of these informants had participated in the original negotiations of the directive in the 1990s, but all of them were involved in the process of its review and revision, which took place between 2004 and 2009, and during which time many of the original controversies as well as some new ones were playing out. So the interviews weren't so helpful to me in understanding the original writing out of gender out of the directive, but they were certainly helpful in understanding the subsequent process, the kind of reproduction of the model that the directive adopted. So for the original writing out, I had to rely more on textual sources. But just to tell you who I talked to, so in Brussels I interviewed 3 members of the European Commission, 2 members of the European Parliament, including Alejandro Cercas, who was the Parliament's rapporteur on working time, as well as representatives of the ETUC and European Public Sector Unions Federation and Business Europe. Unfortunately, and this is kind of a problem, I was not able to interview representatives of the European Women's Lobby, who didn't reply to any of my requests for interview. So I had to gather some information about their positions from other representatives of groups that were friendly to women's groups, such as the public sector unions, for instance, and also from their official statements to the extent that there were any, because as I will suggest later, actually the women's groups weren't that engaged in these debates, which is why perhaps they weren't interested in talking to me, or they didn't find it relevant. I was luckier with this in Poland. In Poland, I was able to interview quite a few women's representatives of women's organizations, in addition to talking to representatives of course, the political parties, social partners, one of the Polish members of the European Parliament who was particularly active on the issue of working time. In total, I conducted 19 interviews. And the purpose of these interviews was to ascertain how these informants perceived and understood what the main rationales for regulation on working time were, and to gather whether or not they considered or saw as important or not the broader social objectives, such as reconciliation of work and family or promotion of equal opportunities, as ones that were also significant in the context of discussions about standard working time. And to also get a sense for whether they saw these rationales are being given some weight in the process of debate around the directive's attempted reform. So this slide just is a snapshot of a little bit of what I found. So in my and it is based more, of course, on analysis, as is clear, is based on analysis of the textual. The textual analysis, specifically my analysis of the various binding and non-binding instruments on working time that had been adopted over time and proposed by the European Commission for the Council to consider. And by looking at them over time, I observed this interesting pattern. Namely, the purpose of working time regulation and the range of objectives that it could support began to be cast in a progressively expansive manner, especially in the 70s and 80s, at the time that the community had actually no competence to regulate in this area. And although during this period, the traditional historical health and safety and organizational objectives continued to be important, there was a host of other regulatory rationales that were being identified. Indeed, it appeared that in absence of a concrete legal peg, during the 1980s, the European Commission actually advocated re-regulation and modernization of working time organization, its reduction and flexibilization, by reference to a fairly broad range of social goals, including those of reconciliation of work and family, more equal distribution of paid and unpaid work, and care between marriage partners. And this was, again, not just in a context of part-time work, which itself was conceptualized and talked of very differently in the 80s than it was subsequently. But this was in the context of standard working time. But all those proposals remain drafts, because there was with no binding effect, because there was ultimately no competence to regulating this area at the time, and any efforts that were made were resisted by the UK in any case, and so all of this, at least in the various proposals that were made in the 70s and 80s, did not amount to a binding provision. In the 1990s, however, the Single European Act changed the treaty, which opened an opportunity for adoption of a binding instrument in the area of health and safety. And so the directive that actually was adopted was specifically adopted under the heading of health and safety. But what happened in the process of shifting to this health and safety treaty legal peg was that all those other considerations disappeared. They were not compatible with the narrow legal basis, and they were erased, or they were simply not included into the actual directive that was adopted, despite the fact that for a couple of decades there was actually, the working time was being discussed quite differently. So not only did the directive's 1990 draft proposal or its 93 final version no longer contain any provisions or references to other social goals, the forms of flexibility that the directive ultimately did sanction were also likely the kinds that would undermine those objectives. But much as the outcry and controversy was about the fact that the directive's extensive flexibility would undermine objectives of health and safety, there wasn't much of an outcry around this non-inclusion of other rationales. And indeed, trade unions at this time were not necessarily pushing for a work, family, or equal opportunities agenda either, as they were ultimately attempting to maintain working time status quo and to get some kind of regulation on working time to begin with. So this is kind of how gender got written out of the law. But what about the development since? So after the directive's original adoption in '93, gender mainstreaming became a legal principle with horizontal application, and work-family reconciliation emerged as a key EU strategy for facilitating employment participation and promotion of equality. And as a result, the directive's first review, which spanned from 2003 and 2009, also saw this expansion, again, of the discussion on the instrument to encompass work-family reconciliation as a significant consideration in rethinking approach to that the directive had adopted a decade earlier. A range of proposals for inclusion of more or less robust provision within the directive that would help to facilitate these goals were made by various parties, including the Parliament majority and the Women's Committee within the Parliament, but also trade unions, who were now much more interested in this agenda and actively promoting the idea that rethinking how standard norms are conceived and how standard time is regulated is necessary to actually support social reproduction. They were even using this language, and to facilitate gender equality by helping women and men redistribute how they share their time, the time they spend on paid and unpaid work. Indeed, the Commission's original consultation documents themselves suggested that an inclusion of a binding provision on work-family reconciliation might be something to explore. Later, however, the Commission downgraded this proposal, instead suggesting that inclusion of work-family reconciliation could be achieved through referring to it in the context of the proposed directive's preamble, so as a broad consideration to take into account scheduling and work, but not a binding provision. The reason for this downgrading had much to do with the business Europe and European business lobbies' opposition, who, while not opposed to work-family issues per se, always contested including them in the context of the directive on the basis that this would not comply with the narrower legal base on which it was enacted. Indeed, the trade unions, who were also very cautious that the legal basis of health and safety shouldn't be stretched too far, and proposed that the working time reconciliation could be regarded as an aspect of health in order to fit into the health and safety basis. And this was a reading that to some extent was supported by the Court of Justice of the European Union rulings on on-call work. In the end, though, so this is again just to represent that all those various discourses were still, and rationales for regulation were still very much present. But gender equality and reconciliation, work and family were still quite marginal. It was really this tension between flexibility, productivity and growth, and health and safety that dominated the discussion, and the other rationales, while there, kept getting pushed. Again, just another way to show that this was always very much a hegemonic, kind of dominant way of thinking about what working time regulation was supposed to achieve at the EU level, with, of course, health and safety being the important social consideration. But those other discourses were always there, but really marginal. So in the end, the dispute over the directive boiled down to the balance between health and safety and the right to flexibly organize the production process, and also about money, because the differences between social partners became mirrored by the differences between Council and the Parliament. By the time of the review, fewer EU member states were willing to support taking out of the directive's most contested provision, the opt-out, which was one of the derogations that I mentioned that was most contested, because by now the opt-out was being used in the context of on-call work in many EU member states. So even though initially the group of states who were opposing the opt-out was much larger, it had also reduced by the time of this renegotiation. So when the review process collapsed in 2009, because there was no agreement on the key issues, work-family had been pushed to the sidelines of the discursive universe once again. Indeed, my interviews showed that even those friendly actors who were championing the more expansive casting of the directive shifted attention to more traditional discourse of securing minimum protective standards, and left gender considerations off the negotiating table because they said insisting on them was simply too politically risky. So the Commission's, so this is, my book ends really with the collapse of these negotiations, and then I try to, and then I move to my Polish case. But most recently, or not so recently anymore, in 2009 or 2010, following the collapse of conciliation, there was another reopening of the working time case by the Commission. Initially, the language of the Commission's communications on this issue suggested that there will be again this expansion of the discursive universe, and perhaps this could translate into legal change, again considerations around women's access to work, but also redistribution of work, unpaid work between women and men was very prevalent. But then after 2 consultation rounds, the social partners again failed to come to a consensus, and the ball was in the Commission's court again. And it's difficult to anticipate what they will do, but one thing that is quite telling is the fact that the Commission's recent consultation on work-life balance and its roadmap on work-life balance does not speak to the Working Time Directive at all. So it speaks again to all the other instruments that regulate aspects of time that are seen as kind of feminized aspects of time, but it does not speak to the directive as something that should be considered in the context of work-life balance, which is now the umbrella term for also work-family reconciliation. So I want to, I hope that I didn't lose you in all the detail, and I'm cognizant of the fact that I talked quite a lot about the way that I conceptualize my study and a bit about methods, but I think the reason I had done so is because the way that it was the concept, the universe of political discourse, that really drove me to more systematically organize how I was looking at what I was looking at, and how I was trying to study this process of erasure and writing out. And so the concept really drove my method. So I wanted to just end with a general reflection on why I think this kind of way of studying the process of policy making and erasure is useful and important. I think first of all, the benefit of this kind of an approach is that it very explicitly seeks out gender and writes it back into the story, which, especially by showing that it actually was not entirely absent in the story, but for various reasons it kept getting sidelined and pushed to the edge, and so it was becoming invisible. It became invisible in some ways because it was always on the sidelines. And I think that without telling such stories, this story, it is quite easy to continue to assume that what we've got also is kind of inevitable, and that it's a product, and that it is not a product of a particular context and a particular negotiated settlement in which not everyone's interests were equally represented. Not just the interests of labor, but interests of women workers, for instance. I think that the other relevant benefit of this, related benefit of this approach is that it very consciously re-embeds law into the political process without necessarily collapsing into the politics or into the social. So in my work, in the way that I studied this, I tried to be very attentive to the legal rules on their own right. But I really try to, I try to be attentive to the rules themselves, but really try to contextualize them. And I also try to interpret them through a specific gender lens that questions their neutrality. And the third point about this particular way of approaching a study of legislative process and regulatory design is that it illuminates how significant representation is in the context of regulatory design. Having feminist interests represented, not only by women's groups, but also by other actors who may be more present in a context of either because they are able to by nature of the design of who gets to be consulted, or because they see their voices as relevant to a discussion. I think whether or not it's women's groups are also getting a feminist message to other groups that then can represent women is quite important. And sorry, just and I think one of the things that I found that was a bit disenchanting was the fact that law has this, hard edge and can really foreclose possibilities for change. And in the case of the Working Time Directive, this legal basis was really limiting. So, when you look for a way, when you're interested in kind of emancipation and you want a transformative project and you want to change and transform, or you want to contribute to the process of doing that, seeing this kind of closure that the law can perform was a bit disconcerting. But I think that it just shows how resistant law can be in this process of gendering and kind of reproducing gender relations. But it also highlights just how important it is that we come up with innovative ways of exposing that kind of constitutive role of law. And I think that's it.